ready to commence? Recording is going? Yes. Very good. I'm calling to order a code enforcement hearing in the city of Cape Canaveral. Today's date is October 22nd, 2024. My name is Richard Geller. I'm special magistrate appointed by the City Council to hear code enforcement cases pursuant to Article 6 of the City Code and Florida Statutes, Chapter 162. These will be quasi-judicial evidentiary proceedings. The burden of the proof is on the city to show by a preponderance of the evidence that a code violation exists. In other words, I will determine based on the evidence presented to me this evening whether it is more likely than not that a violation has occurred. The alleged violator will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or responding party. Anyone who would like to testify should sign the sign-in sheet at the front of the chambers. Upon request, an alleged violator may ask relevant material questions of any city witness, and the city may ask similarly relevant material questions of any witness for the responding party. I may exclude evidence that I deem irrelevant, immaterial, or unduly repetitious. In determining the amount of any fine, I will consider the gravity of the violation, any actions taken by the violator to correct the violation, any previous violations committed by the violator will also be considered. Under the City Code and the Florida statutes, I may assess and order the payment of a fine of up to $250 per day for a first violation and up to $500 per day for a repeat violation. And in exceptional circumstances where the violation is irreparable or irreversible, a fine of up to $5,000, as well as the cost of any repairs made by the city. At the conclusion of the hearing, I will issue findings of fact and conclusions of law based on the evidence of record, and I will also issue an order to follow up in writing. The city will record a certified copy of an order imposing a fine, which will become a lien upon the land where a violation occurs, as well as upon any real or personal property owned by the violator. Any order I issue may be appealed by any party to the Circuit Court for Brevard County within 30 days. It is the responsibility of the appealing party to obtain a record of these proceedings. An appeal is limited to the record presented before me. The city's agenda packet will be administratively accepted into evidence as City's Exhibit 1 and its PowerPoint slides as Exhibit 2. I've signed and approved of the minutes for the August 27, 2024 meeting, which I'll give to our recording secretary, Ms. Roth, at the conclusion here. And the next meeting is added here just a moment ago.
January 28th.
Thank you so much.
25.
January 28th, 2025 for the next meeting. So the first case on the agenda, case number 24-141, the property owner is indicated as Susan Hagen. Hopefully I pronounced that correctly. Is the city ready to proceed?
I would like to first, you see a lot of new faces here, I take it. I'd
I
like
do.
to introduce a couple of our newest code enforcement officers. We have Chris, I'm going to mess up his last name, Fiala, and William Wheeler. You will see them a lot now and probably, hopefully, be presenting cases to you soon.
Terrific. Good to have you all.
Hi, I'm Gerald Coates, Code Enforcement Officer, City of Cape Canaveral.
All right. And is your first name, is it Gerald or is there a D?
Gerald.
There's no D on the end. It's just Gerald. Okay,
Yes.
Mr. Coates, thank you so much.
First case is case number 24209, Daniel McNally,
Okay.
244 Coral Drive. Legal is up there as well as the parcels on the screen. Violation is for property maintenance. Notice of violation. August 16th, 2024. Return receipt on August 22nd, 2024. Notice of hearing is 9/12/2024. Return to sender at 9/18/2024. 9/17/2024. Property was posted in accordance with Florida Statutes 162-12. Notices along with the required posting at City Hall.
Okay.
There's a view of the property right there. On 8/7/24, I conducted a site visit to 2244 Coral Drive, following up on a complaint that was received from Mr. Timothy Bass at 248 Coral Drive in reference to overgrowth of grass and weeds. During the visit, I observed grass and weeds in excess of 6 inches in the front and rear yard. At 8/12/24, courtesy notice was left at the side door to the property. 8/16/24, I conducted a site visit and observed the front yard had been mowed. However, no attempt had been made to mow the rear yard. Grass and weeds are still in excess of 6 inches in height. 8/16/24, a notice of violation was sent to the property owner. 8/23/24, I spoke with the property owner, Mr. McNally, and he stated the overgrowth of grass and weeds would be mowed. 9/12/24, I conducted a site visit and observed the property is still in violation with no further attempt for compliance. 9/17/24, property was posted with a notice of hearing. Here's a picture of the front yard, and you can see the overgrowth of the grass and weeds that is surrounding the mailbox, along with the trailer that's in the background.
Excuse me,
Hold on, can you go back to that here?
Mr. Geller,
Yes.
real quick, everybody needs to be sworn in.
Thank you so much for catching that. That's what I get for going so quickly here. Anyone who intends to give testimony, do you swear the testimony that you have or have given you will give or have given this evening is the truth, whole truth, and nothing but the truth? That's all you got.
I do.
Thank you so much. You can continue.
In continuance, this is the front of the property, and you can see the overgrowth, close view around the mailbox, and rear view of the trailer, and the forefront here of, in front of those.
We're talking in front of the house.
Yes,
That's a trailer top, or what is that?
that's a pop-up camper.
Pop-up camper, so that goes on top of,
That's
How's
a
that
pull
work?
behind. He pulls it, and it's moved from, it's, every now and then you'll see it in the very front and on the side.
I guess I've never seen one off a vehicle, so I'm having trouble visualizing in my head.
It's
So
sitting on, a close view would show it's sitting on a trailer.
oh, I see. Oh, okay, so there's some wheels under there.
Yes.
But that's not part of the violation,
No,
right?
sir.
So it's just he hasn't trimmed around the mailbox here.
Well, he hadn't mowed the grass, period.
Okay. And so you're okay.
There's another view of it.
All right.
And the trailer has been moved forward, and it was in this patch of area right there where.
That looks like, so that's September 10th, according to the date stamp.
September 10th,
Okay.
2024, yes.
And so it's your testimony that the grass here is still too high.
Yes, sir.
Okay.
This is the picture of the backyard showing the grass is even taller.
And that's also on September 10th.
September 10th, yes, sir. Another view, September 10th, taken with the grass still in
Yeah, and I assume that's the backyard?
that is the backyard. This picture was taken October 3rd, still not compliant. This picture was taken on today, showing that the grass is still in excess of 6 inches.
Right.
I don't think he's here.
Okay, I don't see anyone to testify. What is the photographs speak for themselves, frankly. What is the recommendation of the city as far as what kind of time you would like to give Mr. McNally to bring this property into compliance?
Based on testimony and evidence submitted at this hearing, staff request the magistrate find the responsible in violation and give until November 22nd, 2024 to bring this property into compliance.
All right. All right, I'm going to enter an order. This, again, will be reduced to writing, that I find that the official records of the property appraiser do identify the respondent as the owner of the subject property, that the notices of violation, notice of hearing were served and posted in compliance with the city code and the Florida statutes, I'm going to find that multiple site visits were made on multiple dates, establishing that the grass and vegetation far exceeded 6 inches. It looked just terrible and looked like a blight. And that I'm going to find that the respondent is in violation of the property maintenance standards in the city code, section 34-94, which requires good community appearance. Finding violation of section 34-96A, B, and D, which subparagraph A requires maintenance and upkeep of all land improved in the city, that the owner of every single-family dwelling is responsible for maintaining the exterior in a clean, sanitary, and safe condition. Also, D, subparagraph D, that premises shall be kept free of all nuisances. Find that this is a nuisance, a blighting, deteriorating influence on the neighborhood, therefore a violation of subparagraph D. I'm finding a violation of section 34-97. Again, that the owner is responsible for maintenance and not allowing premises to have accumulations of brush and weeds and obnoxious growths. Finding this to be a public nuisance and a violation of section 34-122. That says that all grass areas and yards on improved property shall be properly maintained in a neat and attractive manner and kept free of dead plants. There were plenty of dead grass on the property as well, and and shall further be maintained so that grass, weeds, and other rank vegetation shall not exceed 6 inches in height. There are clear examples in the evidence of record that were exceeding 6 inches, finding a violation of section 82-121. Again, this pertains to maintenance requirements, that property shall be kept free of excessive weeds, undergrowth, brush, dead vegetation. And also subparagraph C of 82-121, yards on developed property shall be regularly landscaped and maintained in good condition pursuant to the property maintenance standards set forth in the city code, which are clearly not being met. The respondent is ordered no later than November 22nd, 2024, to maintain the grass, weeds, and other rank vegetation in a manner not to exceed 6 inches in height, and to confirm compliance with the code enforcement officer. If the respondent fails to timely correct the violations, I would ask the code enforcement officer to schedule a compliance hearing before me, in which case the respondent will be given due notice and will have an opportunity to appear and testify whether the violations are continuing on the subject property. And if they are continuing, I will enter a fine of up to $250 per day that the violation continues. And as stated earlier, that any fines that are issued will in fact become a lien on the property. Next case is 24 actually the first one, I don't know if we misstated this, so it was 24-209 was the McNally case.
Yes, sir.
Okay, so which one do you want to do next? Because that was actually number 3 on the agenda, so let's go back.
Susan Hagan.
Let's go back to Susan Hagan now, and that's the number 1 on the agenda, which is case 24-141.
Case number 24-141, Susan Hagan, 367 Harbor Drive, Cape Canaveral, 32920. Legal parcel ID on the screen. Violations for property maintenance. Notice of violation, 6/26/24. Return receipt, 6/29/2024 to Susan Hagan. Notice of hearing, 9/12/2024. Return to sender, 9/18/24. 9/17/2024. Property was posted in accordance with Florida statutes 162-12. Notice along with the required posting at City Hall.
Yeah, wait, just before, I want to make sure I got all those dates. Would you go back a slide, please?
Yes, sir.
Okay, you can move, you could proceed.
All right, this is a picture of the property
Okay.
on April 29, 24. During morning inspections, I have observed overgrowth of grass and weeds in excess of 6 inches in the front, rear, and side yard. I also observed trash and debris in the front driveway and a large folding ladder in the front yard. Further observation indicated garage door appeared inoperable with the left side completely closed and the right side partially open. A courtesy door hanger was left at the front gate due to aggressive dogs in the front yard. April 30th, 24, I received a telephone call from Ms. Hagan asking about the door hanger left at her property. I explained to Ms. Hagan the violations
Before we move on, can I just interrupt you? So
sir.
I'm just interested in understanding what's going on with the garage. It says the garage door appeared inoperable with the left side completely closed and the right side partially open. Was this lopsided?
Yes, sir, I'm not a garage door guy, but from the looks of it, it's jumped the tracks, and one cable is tight and one's not. And it has been this way for a long time.
So we'll call it a lopsided garage door, only closed on one side.
Only closed on one side.
And this is a single door that's
Yes.
like that. Okay, that's on the side.
I've got a picture of it.
Okay, good. So let's
Okay,
move on here.
May 14th, 24, during daily inspections, I had observed some of the trash and debris located on the front left side of the property had been removed, along with a large ladder in the front yard. May 23rd, 24, received a telephone call from Ms. Hagan advising due to her health problems, she is unable to address any of the violations at this time.
Okay, but just go back to that last slide, if you will. So 30, she said she's going to correct. On May 14, 24, now we got trash and debris. Is this different trash and debris that was in the driveway on the first inspection on 429?
That's the same trash and debris that was removed. I'll have that, you'll be able to see this in pictures that I have.
So this is on the front left of the property. This
Yes.
is the same trash and debris that used to be on the front driveway. She just moved it. If you look at 429, it says observe trash and debris in the front driveway. And here we got trash and debris in the front left side of the property. Is this different trash?
The front and the left side of the property, yes, sir.
Okay, I'm not sure I'm getting an answer to what I'm trying to understand. Is this the same trash and debris?
Yes.
Same trash and
Same
debris.
trash.
So this is also on the driveway?
Yes.
Okay. Well, I guess you'll show me in the photographs, but go ahead. And then she says she's poor health on the 23rd.
Yes.
Okay. Okay, you could proceed.
Yes, sir. All right, on 6/26/24, during a site visit, observed violations still existed. 8/12/24, I conducted a site visit, observed a yard crew was mowing the grass in the front, side, and rear yard. On 9/12/24, I conducted a site visit and observed trash, debris, and weeds had been removed. The garage door, however, remains inoperable.
Okay.
So, Ms. Hagan has done everything that I've asked her to do except for the garage door, and she's,
And in the time since 9/12, has she been continuing to maintain the grass?
yes.
Okay.
She's got a yard crew that has come, and I've saw these
Okay.
mowing the
So-
grass and doing a great effort to put this property in
Okay,
line.
good. So all right. Let's see your pictures now.
Yes, sir. All right, here's the grass and weeds that is accumulated on the left front side of the property. There's the garage door, and there's more of the weeds and grass located underneath that table. And the garage door is at a slant and has been that way for a long time.
Now I understand the garage door.
This is another picture of the front yard, revealing the high grass and the ladder and some of the debris that's accumulated around the front yard. This is another view showing the, what I could see of the back side yard of the tall grass and weeds. All right, this is where it start getting into compliance because this grass has been mowed. And a lot of the weeds that were in the cracks of the driveway and the one on the left front side of that garage, by that garage, have been removed. All right, there's one of the vicious dogs, and,
Is that the respondent's property
Yes,
with the dog?
sir.
Okay.
and you can see that the grass is being kept clean and
Yeah.
nice and mowed.
So I guess the question, and I don't see the representative here.
She called and stated due to a health concern, she's not gonna be able to make it.
Okay, I
She
understand.
supposedly had a crew coming out today to fix the garage door, but they didn't come out.
Okay, so I guess the question for the city is, I have two options in front of me. One, I can find that she was in violation of the provisions governing the vegetation, the 6 inches and all that. Or we could, and if I were to find that she was in violation, if it goes back into violation, then it's a repeat violation where she would be liable for up to $500 instead of $250. The other alternative is just confine any order I issue to the garage door issue. And,
Yes.
maybe given her health and that she has apparently hired this crew, they've been maintaining it for a month, maybe the city just wants to concentrate on the garage.
She has made an effort, and she stays in contact with myself
Oh, good, okay.
and lets me know what's going on. And she is really working on trying to get this repaired.
Okay. So in that case, I guess we're in agreement. Let's focus the order on getting the garage fixed, and then she'll be in total compliance.
Yes, I'm good with that.
All right. And how much time is reasonable to get the garage fixed? If it's a matter of just fixing some cables and whatnot, I mean, it shouldn't take too long.
I want to give her till November 22nd.
Okay. All right. So, all right, so I'm gonna just confine my order to the garage door, and I'm gonna find that the respondent is in fact the subject owner of the property, that there were numerous inspections that began on April 29, 2024, that found the garage door inoperable and that apparently either jumped the tracks or the cabling is out of needs repair, and that this condition has been continuing up until possibly to the present day, although she has notified the city by telephone that she has hired someone to fix the garage door. Is that correct?
That's what she was always told.
Okay. I'm going to find that the notices of violation, the notices of hearing, all complied with the city code and Florida statutes. I think I am finding a violation of the property maintenance standards set forth in the city code, section 34-94, good community appearance, maintenance and upkeep. That the exterior must be kept in a clean, sanitary, and safe condition. The garage door does not appear to be safe. Says that all parts of a single-family dwelling shall be maintained in good repair, shall be capable of performing the function for which each structure or part thereof was designed or intended to be used. That's clearly in violation. Exterior property shall be kept free of, second here. Well, exterior property shall be kept free of all nuisances, all conditions which may create a health hazard, or even a fire hazard. If that garage door is not operable, it's one less exit from a house that could be on fire. So I'm going to find a violation of this subparagraph D of 3496. I'm going to find a violation of 34-122. Strike that. That's referring to the grass yards. I'm going to order that the respondent have the garage door repaired or replaced, and so that it is in compliance with the code no later than November 22nd, 2024, that she must obtain all required permits to either repair or replace the garage door, and to have a final inspection performed, and also to confirm compliance with the code enforcement officer. And as stated in the previous case, any failure to comply, I would direct the code officer to schedule a compliance hearing before me, in which case the respondent may be subject to fines in an amount of up to $250 per day per violation, and that any fines that are imposed would become a lien on the subject property and any other personal, real or personal property that she may have. I'm ready to move on to the last one. This is Diane Bateson, if I'm pronouncing that correctly. Case number 24-208.
Case number 24208, Diane Bateson, address 8801 Seashell Lane, legal and parcel on the screen. Violation is for work without a permit. Notice of violation 8/8/24 was returned to sender on 10/4/2024. 8/20/24, property was posted in accordance with Florida Statute 16212. Notices along with the required posting at City Hall. Notice of hearing 9/16/2024. Return receipt 9/19/2024. There's a picture of the property. On 5/30/24, McFence and Duck submitted a permit application for a 5-foot fence. On 6/4/24, Officer Palmer, the deputy manager, sent an email to the applicant informing them the fence was within 25 feet of a right-of-way and could not exceed 4 feet in height. On 6/11/24, Director Code Officer David Dickey contacted Officer Palmer and asked him to call Ms. Bateson regarding the fence. Officer Palmer made contact with Ms. Bateson and explained to her, according to City Code Section 110-470, no fence can exceed 4 feet in height within 25 feet of a right-of-way. Ms. Bateson stated Mr. Dickey told her she was allowed to erect a 5-foot fence. Officer Palmer stated he would contact Mr. Dickey in reference to her statement. Officer Palmer made contact with Mr. Dickey, who stated he did not tell Ms. Bateson she could have a 5-foot fence within 25 foot of a right-of-way. He did state she could apply for a variance. A variance packet was sent via email to Ms. Bateson. 6/12/24, Ms. Bateson submitted an incomplete variance application packet. Ms. Bateson stated on her application she would not pay the application fee until her variance was approved. 6/17/24, the city senior planner contacted Ms. Bateson, informing her the variance packet was incomplete and must be paid for prior to moving forward. On 7/25/24, McFence contacted the building department and stated they were canceling the application for the fence permit. Sir, I've got Officer Palmer is here that can testify to the fact that all that I read just now.
Yeah, that's fine.
Okay.
This is admissible evidence in this hearing. We're not bound by
right.
by
Yes, sir.
excuse me, the evidentiary rules that would apply in a court of law. So
All right. 8/2/24, during morning inspections, I observed a new aluminum open picket fence exceeding 4 feet in height erected at 8801 Seashell Lane without first obtaining the required permit through the city of Cape Canaveral. Staff tried to notify the property owner, however, the owner was not home. A courtesy notice with business card was left with person staying at the property requesting a code enforcement be notified when the property owner is available. On 8/8/24, as of this date, no contact had been made from the property owner. A notice of violation was mailed certified to the property owner. On 8/20/24, posted property with notice of violation in accordance with Florida Statute 16212, notices along with the required posting at City Hall. 9/9/24, a search of the permit database revealed no permit had been issued. On 9/10/24, Ms. Diane Bateson contacted me via telephone and informed me, due to her job, she's often out of town and she had no idea who erected the fence once she was away. She further stated she thought the fence company had applied for and obtained the permit. Ms. Bateson further stated she would apply for a fence permit on September 14th, 2024. 9/13/24, no permit application had been submitted for the fence. On 10/18/24, a permit application was submitted for the fence, which has already been installed. The permit application is for a 5-foot fence, which is in violation of the city code. This picture was taken on 7/19/2024. This is a Friday. There is no fence. This picture was taken on Monday, 7/22/24, and there is a fence. This is another view of the fence taken on October 3rd. Another view taken on October 3rd. This is a side view along the sidewalk, October 3rd. And this picture was taken to indicate that this fence exceeds 4 feet.
Sure does. I assume that I don't see the property owner here. So this is going to be more than just getting a permit. I mean, a permit cannot be issued even retroactively for construction that is in violation of the code.
She was told that.
So she needs to go to the, is it called the variance board here, or the Board of Adjustment, or what is the proper name?
Yes, she would have to apply for a variance first
Yeah.
for the 5-foot fence, so she has a few options. She can remove the 5-foot fence, she could cut the 5-foot fence down to 4 feet, or she could apply for a variance for the 5-foot fence. Once she completes the whole variance packet, then she would go in front of the Planning and Zoning Board.
Okay, so it's the P and Z then that
I believe it's P and Z.
Okay.
I can't guarantee that.
all right.
Is it? Yes, it is.
Thank you. So, all right. It's, the oppositional behavior doesn't sit very well with me. What is Mr. Palmer stated the different options that she has. So what do we want to, what kind of deadline do we're still going this November 22nd deadline to?
Real quick, sir, I would like to enter into evidence. This is the variance package that she submitted.
Okay.
And the reason why I would like to enter this into evidence is on the page for the submittal fee, she has written on here to be submitted when permit approved, fee to be determined. And this is a statement that's been notarized from our permit tech on a discussion that she had with Ms. Bateson. I would just like to submit these as evidence.
If you could give them to Ms. Roth, and I will acknowledge those as exhibits in my written order.
Thank you.
But go ahead and those will be exhibits 3, city exhibits 3 and 4, if you would. I'm going to accept your description of the statement. She'll submit the payment after she gets her variance, and then the other statement by the city official. Well, can you paraphrase what that says?
Yes, it speaks on a conversation that she had with Ms. Bateson in reference to the fence. She had first told us that she had no idea who put the fence up. In this statement, she tells the permit tech that it was actually the person she hired to begin with, the MC, I don't remember their name. MC Fence and Deck. She stated that they were actually the ones that came out and put up the fence. She went ahead and let them. So in other words, she actually let them continue knowing that they required a permit, along with the fact that the contractor knew that a permit was required also. I just wanted that to be in the record.
I don't find the statement that she had no idea who installed her fence. I don't find that credible in the least. And that's a rare finding for me. I think most citizens who come to the city are honest, and citizens who've appeared before me have been honest. That's just not credible. I have no idea who installed a fence on my property. So going back to my question, shall we go with the November 22nd deadline to? Yes, now, is it going to be November 22nd to either remove the fence or cut fence to 4 feet? I assume that can possibly be done. The variance process, that would take months, I would assume. And so, should we give her till November 22nd to submit a variance application with all required fees?
A complete variance package.
Or complete variance application with all fees? All right, so that's what we'll do. That'll be the order. By November 22nd, either remove the fence, cut the fence to 4 feet, or complete or submit a complete variance packet with all fees paid to the city. And she'll be required to contact the Code Enforcement Division to advise as to her compliance with the order. And if there's a failure to comply, again, the direction would be to schedule a hearing before me to issue fines, which may be entered into an amount of $250 per day per violation. The violations here, as were given to the property owner, and I do find that the respondent does own the subject property. We're talking violations of Section 82-31, which incorporates the Florida Building Code, and in particular, Sections 105.1, which requires permits, and inspections, which is Section 110.1, clear violation there. And I also will add that the notice of violation, notice of hearing complied with the city code and Florida statutes. And I'm also going to enter into my findings the various inspections that were done and the chronology of the property owner being advised about the 4-foot rule, and my finding that the doesn't know who installed the fence is not credible. And I'll get this in the other orders prepared this week. Do we have any other business to deal with tonight?
No, sir.
All right, so again, apologies for starting late. It was the first time, and I don't know how many years I've been doing this now. I've never been late for a hearing, and I was just totally bottlenecked up in traffic. So I'm glad that we could get these knocked out tonight, and appreciate everyone showing up, and nice meeting all the new code enforcement officers this evening. So thank you again. We'll adjourn the hearing.